Welcome back, kapatid! In this video, I will be discussing conspiracy and proposal. Conspiracy. There is conspiracy when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. Requisites of conspiracy. 1. Two or more persons come to an agreement. 2. The agreement presupposes meeting of the minds of two or more persons. 3. The agreement pertains to a commission of a felony. 4. Agreement to effect what has been conceived and determined. 5. The execution of the felony was decided upon. The general rule as to liability. In conspiracy, the act of one is the act of all, and the conspirators shall be held equally liable for the crime. Example: if there is a conspiracy to commit rape, each of the conspirators is responsible not only for the rape committed personally by him, but also for the rape committed by the others as well. However, in order to hold an accused guilty as co-principal by reason of conspiracy, it must be established that he performed an overt act in furtherance of the conspiracy, either by actively participating in the actual commission of the crime or by lending moral assistance to his co-conspirators by being present at the scene of the crime, or by exerting moral ascendancy over the rest of the conspirators as to move them to executing the conspiracy. Mere knowledge, acquiescence to, or approval of the act without cooperation or at least agreement to cooperate is not enough to constitute a conspiracy. When liable even if the co-conspirator is not in the scene of the crime. 1. If he is a mastermind, he does not have to be in the scene of the crime to be co-conspirator. 2. If he performs an overt act in the performance of the conspiracy, even if it is not in the scene of the crime per se, like the driver of a getaway car who planned the crime as well, or the man who presses the button of a remote control bomb and the bomb exploded a few streets away. Proof needed to prove conspiracy. Direct proof of a previous agreement among the accused to commit the crime is not necessary, for conspiracy may be inferred from the conduct of the accused at the time of their commission of the crime that evinces a common understanding among them on perpetrating the crime. The following are the exceptions to the general rule, or instances when the accused is not liable as co-conspirator. First, when there is disassociation. To exempt himself from criminal liability, a conspirator must have performed an overt act to disassociate or detach himself from the conspiracy to commit the felony and prevent the commission thereof. Second, one who joins the conspiracy after the crime is consummated. One who joins a conspiracy after the felony subject of conspiracy has been completed or consummated is not criminally liable as a conspirator. When a crime has been fully committed, one not already guilty is too late to be a sharer in it, though if it is a felony, he or she may become an accessory under the penal code. Exception to the exception. When the act constitutes a single indivisible offense. Ways of committing conspiracy. There are two ways of committing conspiracy. 1. Express conspiracy, and 2. Implied conspiracy. Express conspiracy happens when there is an express agreement. Implied conspiracy, or the doctrine of implied conspiracy, holds two or more persons participating in the commission of a crime collectively responsible and liable as co-conspirators, although absent any agreement to that effect, when they act in concert, demonstrating unity of criminal intent and a common purpose or objective. The existence of conspiracy shall be inferred or deduced from their criminal participation in pursuing the crime, and thus the act of one shall be the act of all. Two kinds of conspiracy. 1. Conspiracy as a felony. 2. Conspiracy as a manner of incurring criminal liability. conspiracy as a felony. The mere conspiracy is the crime itself. This is only true when the law expressly punishes the mere conspiracy. Otherwise, the conspiracy does not bring about the commission of the crime, because conspiracy is not an overt act but a mere preparatory act. Note that in conspiracy to commit treason and conspiracy to commit rebellion, if one of the traitors or rebels actually commits treason or rebellion, conspiracy loses its juridical personality and it becomes a mode to commit a crime. Conspiracy as a manner of incurring criminal liability. There must be an overt act done before the co-conspirators become criminally liable. If they commit treason, rebellion, etc., they will be held liable for it, and the conspiracy which they had before committing the crime is only a manner of incurring criminal liability, not a separate offense.
Proposal. Proposal exists when the person who has decided to commit a felony proposes its execution to some other person or persons. Requisites of proposal. 1. That a person has decided to commit a felony. 2. That he proposes its execution to some other person or persons. 3. The proposal need not be accepted, or else it shall be a conspiracy. The proponent must be determined to commit the crime, and he did not just express a wish or advice, or that his words are not equivocal. General rule as to liability. These are still preparatory acts and therefore are not as a rule punishable. Exception: when there is a specific provision of law punishing a specific kind of proposal. There is no crime of proposal when 1. The person who proposes is not determined to commit the felony. 2. There is no decided, concrete, and formal proposal. 3. It is not the execution of a felony that is proposed. Note that it is not necessary that the person to whom the proposal is made agrees to commit treason or rebellion. For our next video, I will be discussing recidivism. Subscribe ka sa channel na to para sabay-sabay natin abutin ang ating mga pangarap. Just comment your questions if there's any and we will try to answer them. Thank you.